Your concealed carry permit might be worthless right now. Not next year, not after some future vote, right now. And if you are still carrying without knowing what the Supreme Court just did, you could be walking into a federal felony charge without even realizing it. Stay with me for the next few minutes, because what I am about to break down could be the most important thing you hear all year as a gun owner in the U.S. Here is what the media is getting completely wrong. They are screaming about a Supreme Court shakeup. They are using words like landmark and historic, but they are burying the part that actually affects you at 3 in the afternoon on a Tuesday when you are just driving home from work. I am not going to do that to you. I am going to tell you exactly what changed, exactly what it means for your permit, and exactly what you need to do before this new legal reality catches you off guard. Subscribe right now if you have not already, because 90% of gun owners will never hear this explained in plain English. And the ones who do not hear it are the ones who end up in handcuffs. Let us start with the real situation. The Supreme Court has been quietly reshaping the legal framework around gun rights for several years, and in their most recent rulings, they have sent a message to every lower court in the country. That message is this: the rules have changed. The way courts evaluate gun restrictions is fundamentally different now than it was just a few years ago. And most gun owners, most permit holders, most law-abiding concealed carriers have no idea how deep this shift goes. Here is why this matters to you personally. When the Supreme Court changes the standard courts use to judge gun laws, every single gun law in the country becomes open to challenge. State laws, local ordinances, permit requirements, carry restrictions, all of it. And that creates a window, a legal window that can help you, but it can also create confusion that traps you. Let me give you the legal foundation in plain language. No law school degree required. For decades, courts used what they called a means-end test to decide if a gun law was constitutional. Basically, the government would say, "We have a good reason for this restriction," and the court would ask, "Is that reason important enough?" That system was tilted heavily toward the government. They could restrict your rights as long as they had a story that sounded reasonable. The Supreme Court threw that system out. In the Bruen decision, and in the rulings that followed, the court said the new standard is historical tradition, meaning if the government wants to restrict your gun rights today, they have to show that a similar restriction existed back in 1791 when the Second Amendment was ratified. That is a massively higher bar. And courts across the country are still scrambling to figure out what it means. Here is where it gets dangerous for you specifically. Because courts are still figuring this out, there is enormous inconsistency right now. A restriction that is perfectly legal in one circuit might be unconstitutional in another. A permit requirement that stands in one state might get struck down in a neighboring state. You could be legal in the morning and a criminal by sundown if you cross the wrong county line. I am not exaggerating that. Several lower courts have already issued contradictory rulings on the same types of laws. The Eighth Circuit said one thing, the Ninth Circuit said another, and the Supreme Court has to sort through all of this. While they do, you are caught in the middle. And that is precisely why what I am about to tell you matters so much right now. Let us talk about what this means for your specific permit. Concealed carry permits are issued at the state level, and states set their own requirements: training hours, background check standards, mental health reporting, residency requirements. Under the old framework, states had a lot of flexibility to add restrictions as long as they could argue a safety reason. Under the new Bruen framework, those restrictions are under the microscope. Some states are already seeing their requirements challenged in court. States that required proof of good cause or proper reason to get a permit have already been struck down by federal courts applying the new standard. New York tried to fight it. California tried to fight it. Hawaii tried to fight it. They all lost. But here is the problem nobody is talking about yet. When a law gets struck down, there is chaos in the transition period. Enforcement becomes unpredictable. Officers on the street may not have updated training yet. Prosecutors may still be pushing charges under laws that technically no longer hold. Meaning you could be arrested under a law that a court already gutted, and it could take months and thousands of dollars in legal fees to sort out. Here is what most gun owners get completely wrong about all of this. They think that if the Supreme Court rules in favor of gun rights, everything automatically gets better immediately. It does not work that way. These rulings filter down slowly. They travel through circuit courts. They travel through district courts. They travel through state attorneys' general offices and local prosecutors. By the time the change actually reaches the officer who pulls you over on the highway, months or years may have passed. During that gap, your rights are most at risk, because you are playing by the new rules, but the system around you is still running on the old ones. This is the danger zone, and you need to know how to navigate it. Let me break down the practical implications state by state in broad strokes. If you live in a shall-issue state, you are generally in better shape. The new Supreme Court framework tends to support shall-issue systems, where the government must issue you a permit if you meet the objective requirements. If you live in a may-issue state, pay very close attention. These are the states where officials had discretion to deny your permit even if you met the requirements. That system is being dismantled right now by the federal courts, but the transition is messy and it is not yet complete everywhere. If you live in a constitutional carry state, you might think you are safe from all of this, and in many ways you are. But the surrounding states matter. If you travel with your firearm, you are entering legal territory that may be in total flux right now. One wrong turn across a state line could become the worst day of your life. Now let us talk about what you actually need to do, because information without action is worthless. Step 1. Pull out your concealed carry permit right now and check the expiration date. This sounds obvious, but tens of thousands of people are carrying on expired permits because they assume the renewal process was automatic. It is not. And in some states, carrying on an expired permit is a felony, not a misdemeanor. Step 2. Look up whether your state's permit laws have been challenged in federal court in the last 18 months. This is public record. A quick search with your state name and the words concealed carry court ruling will show you if there is active litigation affecting your permit status. Step 3. If there is active litigation, call a firearms attorney in your state. Not a general practice attorney, a firearms attorney who tracks these cases daily. One call can tell you whether your current permit is solid or whether you are operating in a legal gray zone. Step 4. Know the laws of every state you carry through. Not just your home state, every state you drive through on a regular basis. Reciprocity agreements can be canceled with very little public notice, and a state that honored your permit last summer may not honor it today. Here is the scenario I want you to think about seriously. You are on a road trip. You are fully legal in your home state. You are carrying your firearm in the exact way your permit allows. You cross into a neighboring state where there is active litigation around carry permits. An officer pulls you over for a routine traffic stop. He asks if you have any firearms in the vehicle. What do you say? This is the moment where preparation determines your outcome. You need to know that state's duty to inform law before you ever cross the border. Some states require you to immediately disclose that you are armed. Some states do not require disclosure unless you are directly asked. Some states have conflicting laws right now because of recent court rulings. Not knowing this is not a defense in court. Saying, "I did not know I had to tell you," will not keep you out of a cell. This is why education is not optional for gun owners anymore. It is survival. Let me tell you about the Fifth Amendment connection that almost no one is discussing. The Fifth Amendment says the government cannot compel you to incriminate yourself. Most people think this only applies in a courtroom. It does not. It applies at a traffic stop. It applies when an investigator knocks on your door. It applies when you are filling out a permit application. Here is the critical point. As gun laws shift and evolve under these new Supreme Court standards, there will be questions asked of you by law enforcement that are designed to establish whether you are in compliance with old laws or new laws. And answering those questions without legal counsel can trap you. You have the absolute right to say, "I would like to speak with an attorney before answering any questions." That sentence has kept more innocent people out of prison than any other sentence in the English language. Say it politely, say it clearly, and then stop talking. This is not about being uncooperative. This is about understanding that the legal landscape is shifting, and every word you say is being evaluated against a framework that even the courts have not fully figured out yet. Here is a development that should concern every gun owner who believes these court wins are permanent. They are not. State legislatures are already working on new laws designed to comply with the historical tradition standard while still restricting gun rights as much as possible. They have entire legal teams studying colonial-era gun regulations, looking for historical precedents they can use to justify new restrictions. This is a chess match, and the government has unlimited resources to play it. Your best defense is constant awareness. Knowing when new laws pass in your state, knowing when those laws are challenged, knowing when your permit status might be affected. That is not paranoia. That is responsible gun ownership in the 2026 legal environment. Let me address red flag laws directly, because this is where the new Supreme Court framework is most contested. Red flag laws allow courts to remove your firearms based on a claim that you are a danger to yourself or others. They operate on what is called an ex parte basis in most states. That means a judge can sign an order removing your guns before you ever get a chance to speak. Under the old framework, courts were fairly deferential to these laws. Under the new Bruen framework, red flag laws face serious constitutional questions. Because you are being stripped of a right without the kind of due process the court now demands, and because the government has to show historical tradition for the practice, which is a much harder argument to make for laws that did not exist in 1791. Several red flag laws are currently being challenged in federal courts using exactly this argument. But here's the brutal reality. While those cases work their way through the system, the red flag law in your state is still in effect. Officers will still execute those orders. Your firearms will still be seized, and getting them back can take months of legal proceedings, even if you are completely innocent. This brings me to what I believe is the most important practical step any gun owner can take right now. Know your state's red flag law in detail. Know who can file a petition against you. Know what the timeline is for a hearing. Know what evidence can be used. Know whether you have a right to an attorney at that hearing. In some states, you do not automatically get legal representation at a red flag hearing. You have to show up and defend yourself, while the state has a trained prosecutor arguing against you. That is not a fair fight unless you walk in prepared. Print out your state's red flag statute. Read it. Keep it somewhere accessible. And have a firearms attorney's phone number saved before you ever need it. Because the time to find a lawyer is not when the police are at your door at 6 in the morning. Let me close with the big picture, because I want you to leave here with clarity, not just fear. The Supreme Court has fundamentally changed the rules in favor of lawful gun owners. That is genuinely good news for the Second Amendment. The bar for restricting your rights is now higher than it has been in decades. But the transition period we are living through right now is dangerous. Old laws are still being enforced. New laws are being written in response. Courts are issuing contradictory rulings, and gun owners who are not paying attention are getting caught in the middle. Your job right now is simple. Know your permit status. Know the laws of every state you carry in. Know your constitutional rights and how to invoke them calmly and clearly. And have a firearms attorney you can call before you ever need one. These are not complicated steps, but they are the steps that keep you free. The Supreme Court can change the rules, but only you can make sure you are playing by them correctly. Stay informed, stay prepared, stay legal. If this breakdown helped you understand what is happening right now, hit that like button and subscribe. I break down these legal shifts every single week in plain language, so you do not have to spend hours reading court opinions you did not go to law school to understand. Click the notification bell too, because my next video covers the exact words to say at a traffic stop that protect your rights without escalating the situation. They are short, they are simple, and they have been tested in courts across the country. You want to know those words before you ever need them, not after. We will see you in the next one. Stay safe, stay legal, stay free.